Let me tell you the three big mistakes that you could make in your pretrial deposition testimony. Hi, I'm Guy DiMartino. I am a Northwest Indiana personal injury lawyer. I have been in thousands of depositions in my years of practice. Clearly, the three biggest mistakes are these. The first is not being open and honest with your lawyer about the good, the bad, and the ugly. I can tell you so many times where folks think that if they don't tell me that somebody is not going to find something out. I can tell you that things are in public records, things are in medical records all over the place. There's nothing that I can't handle and help you deal with if I know it in advance. In the middle of a deposition, though, I can't help you if you hid from me a fact of some criminal matter or some type of medical condition or some type of injury that pops up in your medical records. So that is the first big mistake, holding something back from your lawyer, whether it's inadvertent or not. You know, many times I will ask folks, hey, have you ever had problems with your neck before? And they say, no, never. And I'm like, are you sure? And then we start digging through and I'm talking to them for an hour later, something comes up regarding a neck. And I say, well, I thought you said that you never had a problem with your neck before. And the response is, well, not like this. That wasn't the question. You need to be open and honest with your lawyer about everything. That's number one. Number two, don't volunteer anything. A deposition is a question and answer period. What that means is the other lawyer is going to ask you a question, and you are going to answer that question and answer that question only. If they want to follow up on your answer, let them do that. Do not have diarrhea of the mouth. Do not keep on talking, especially when the other lawyer is thinking about their next question or something along those lines. See, when folks are nervous in the deposition process and there's dead air, instead of just sitting there and waiting for the other lawyer to ask you a question, you think that you have to fill the dead air and you start talking or you stop talking when you have finished your answer. It's okay that there is dead air. Answer the question, answer only what was asked. So, first thing, be open and honest with your lawyer about everything. Second thing, only answer the question. Third thing, do not lie. And a lie could be a little lie. These cases are cases about credibility. And there are two ways that folks can lie. Number one is they can embellish. They could exaggerate. The second way that folks can be considered lying is that they can underplay the problem. They can minimize their condition. You see, either minimizing it or exaggerating it, when it's down on paper, if there's something else in a medical record or in a document or in work papers that will contradict what you have said in your deposition, whether it is an exaggeration or a minimization, can destroy your case. You see, these cases, civil cases, are only about credibility. If you are bringing the claim, you need to be the most credible person in the room. So in order to be credible, you need to be open and honest about the good, the bad, and the ugly. You want to answer only the questions that are asked, and you don't want to minimize, you don't want to exaggerate, because those can be twisted when they look on paper to say that you were lying. If you have any questions about a Northwest Indiana personal injury matter, you can always reach out to me. I am Guy DiMartino, meeting you at the intersection of law and medicine. Have a great day.